The Challenger space shuttle disaster, often referred to as the Challenger explosion, was an orbiter that broke apart in 73 seconds after its launch, killing all 7 crew members on board. The disaster occurred on the morning of January 28, 1986 as a result of 2 O-ring failures. The conditions, events, and decisions that were made prior to the Challenger launch is what makes this case so intriguing. Leading up to the launch, there were 6 days of delays due to weather and mechanical difficulties. The delays resulted in NASA making poor decisions so that they don't further postpone the launch. Since the O-rings in the solid rocket boosters are designed to function at a certain temperature range, NASA's decision to launch the shuttle in below freezing temperatures resulted in the O-rings failing during launch. This allowed for a leakage to occur, which ultimately led to the disintegration of the vehicle. Now we're going to go over the ethical and legal issues of the Challenger explosion from the perspective of a modern engineer in Ontario. At the time of the launch, the temperature was below freezing. The engineers who made the decision to launch in these cold temperatures, knowing fully the consequences of an impaired O-ring, breached sections 77.1, which says it is the duty of a practitioner to the public, to the practitioner's employer, to the practitioner's client, to the other members of the practitioner's profession, and to the practitioner to act at all times with, number 1, faith and loyalty to the practitioner's associate, employers, clients, subordinates, and employees, and number 2, fidelity to public needs. 77.2.1, a practitioner shall regard the practitioner's duty to public welfare as paramount, and 77.8, which states, a practitioner shall maintain the honor and integrity of the practitioner's profession and without fear or favor expose before the proper tribunals unprofessional, dishonest, or unethical conduct by any other practitioner. Thus, the engineer can be held accountable for professional misconduct as defined by sections 72.2a negligence, 72.2b failure to safeguard life, 72.2c failure to report unsafe conditions, and last but not least, 72.2d, failure to make responsible standards and regulations. Now, in this situation, the engineers could have done a variety of things. Number 1, the design flaw with the solid rocket boosters was known 1 year prior to launch, so they had plenty of time to raise the issue to management to prevent the launch from occurring. Number 2, if NASA neglects their findings, they can consult PEO and whistleblow if needed. Number 3, they could have just done nothing, which is pretty much what happened. Now, obviously, doing nothing wouldn't be the ethically correct choice of action. The best choice would be to consult the PEO and go through the process of whistleblowing. This would probably come at the cost of their jobs, but that would be the ultimate sacrifice to protect public welfare, since that is the engineer's duty. The legal case will deal with the tort law and the negligence that occurred prior to the Challenger launch. From the Donegan and Stevenson case of 1932, we know that for a tort to be committed, there are 3 conditions that must be satisfied. Number 1, the defendant owed the plaintiff a duty of care. Number 2, the defendant failed to provide that duty of care. Number 3, the plaintiff incurred loss or damage as a result. In this case, the families of the astronauts are the plaintiffs. The defendants would be the engineers and management at NASA, and by vicarious liability, it would be NASA itself. All 3 conditions of tort law are satisfied, since NASA owed the astronauts a safe journey, in other words, a duty of care. NASA has failed to provide their duty of care by neglecting the warnings given to them by their staffs and engineers about the conditions of the launch, which resulted in the tragic death of 7 astronauts. As for the conditions of liability, all of the relevant conditions are satisfied. Number 1, a claim was made within 2 years of discovery. Number 2, and the claim was made within the 15 years of the original act. Number 3, there are no disclaimers in this case, so this is irrelevant. Number 4, finally, gross misconduct is clearly evident since the administration at NASA neglected the forewarnings of their engineers and showed disregard for the safety of their shuttle crew. In this case, for the Challenger explosion, the court would likely rule in favor of the plaintiff and hold NASA accountable through vicarious liability for their actions, requiring them to pay back the families for what they have lost. Overall, the Challenger explosion is widely used today as an example and learning experience for the engineering safety and workplace ethics. Although the loss of these astronauts is still mourned today, we will remember them through what could have been done to prevent their deaths.